कमिशनच्या वतीन हार्दिक हार्दिक स्वागत करता आणि विनंती करता प्रास्ताविक आणि तुमचे सगळ्यांचे स्वागत करपाची विनंती हांव करता श्री आत्माराम बर्वे सरान स्टेट इन्फॉर्मेशन कमिशनर तांच्यांनी तुमचे सगळ्यांचे स्वागत आणि प्रास्ताविक भाषण करचे सर प्लीज.
गुड मॉर्निंग एवरीवन. आज बरं दिसलंय की या कार्यक्रमाचे सूत्रनिवेदन बऱ्या स्पष्ट आणि सुंदर अशा कोंकणी भाषेतल्यान जाता. नॉर्मली आम्ही सरकारी कार्यक्रम म्हणले की इंग्रजी भाषेचो भरपूर वापर जाता. इंग्रजी भाषेबद्दल काय ऑब्जेक्शनेबल ना, पण तरी सुद्धा शक्यतो स्थानिक आमची जी भाषा आसा, राजभाषा आसा, तिचो वापर सरकारी कार्यक्रमांतल्यान जाता ही एक बरी गजाल. आणि याच अनुषंगान एक गजाल म्हणजे सुरवेकूच हांव तुमचे स्वागत करच्या पयलीं जाहीर करपाक सोदता की RTI एक्ट जो आसा 2005 हाजे सेक्शन 26 जे आसा ते उद्धृत करता की प्रत्येक राज्यान हो कायदो आपल्या राजभाषेन प्रसारीत करचो, जेणे करून हाजे सामान्य मनशापर्यंत हाजे सगळे प्रोविजन्स तितल्यो सगळ्यो तरतुदी पावच्यो. पण काय कारणांक लागून हे ट्रान्सलेटेड व्हर्जन जे कोंकणीतले आशिल्ले ते अजूनपर्यंत तयार जावंक नाशिल्ले. पण श्री अरविंद कुमार नायर आणि हांवें जेन्ना ह्या कमिशनाचो ताबो घेतला तेन्नाच्यान आमी ही कार्यावळ सुरू करून बेगीनूच कोंकणी भाशेंतल्यान हो कायदो सगळ्यांक उपलब्ध करतले हे आमी जाहीर करता. आजच्या ह्या कार्यावळीक आमच्या वांगडा वेदीर आसा गोंय राज्याचे लर्नड ॲडव्होकेट जनरल देविदास पांगमजी, त्याचबरोबर चीफ इन्फॉर्मेशन कमिशनर श्री अरविंद कुमार नायर, त्याचबरोबर आमचे डायरेक्टर ऑफ इन्फॉर्मेशन अँड पब्लिसिटी श्री दीपक बांदेकर आणि आमचे सेक्रेटरी गोवा स्टेट इन्फॉर्मेशन कमिशन श्री सुधीर केरकर, त्याचबरोबर माझ्या समोर तुम्ही बशिल्ले सगळे मानेस्त पत्रकार बंधू भगिनी. सुरवेक म्हणले तशें कोंकणी भाशेंतल्यान सुरवात जाल्या, पण हांव म्हजें भाशणूय बायलिंग्वल कोंकणी आनी इंग्लीश अशें दवरतलो, जेणे करून सगळ्यांक कळपाकूय आनी समजपाक इंटरॅक्शनाक बरें पडटलें. Today, on the occasion of the Right to Information Day, I am honored as well as humbled to stand before you. We are here to celebrate not only the Right to Information Act, but also the spirit of transparency and accountability that is the backbone of a thriving democracy. आम्ही सगळे या एका डेमोक्रेटिक सेटअपाचो भाग आसा. आम्ही सरकारी अधिकारी असो किंवा सामान्य नागरिक असो किंवा एखादे तटस्थ कमिशन असो किंवा कोर्ट असो, हे सगळे ह्या लोकशाही प्रणालीचे आम्ही भाग असतात. आणि राईट टू इन्फॉर्मेशन ऍक्ट हो एक ह्या लोकशाही प्रणालीचो म्हणजे लोकशाहीचो जो एक पाया असा, लोकशक्तीर विशिष्टते असे जे म्हणले वता, पॉवर टू द पीपल. सो ही पॉवर टू द पीपल जी असा ती पॉवर आणि अकाउंटेबिलिटी दोन्ही एन्श्युअर करपी अशें एक लेजिस्लेशन म्हणजे राईट टू इन्फॉर्मेशन ऍक्ट. या राईट टू इन्फॉर्मेशन ऍक्टाची अंमलबजावणी 2005 सालासावन सुरू झाली. 2005 सालापासून ते आता 2024 पर्यंत कालांतरान वेगवेगळी इंटरप्रिटेशन झाली. वेगवेगळ्या कमिशनांनी ताचे इंटरप्रिटेशन केले, पब्लिक इन्फॉर्मेशन ऑफिसरान आपल्या स्तराचेर ताचे इंटरप्रिटेशन केले. तुम्ही एज फर्स्ट एपेलेट ऑथॉरिटी ताचे निरंतर तुम्ही इंटरप्रिटेशन करतात. त्याचबरोबर हांगा जे कमिशनानूय जे इंटरप्रिटेशन जाता, कमिशनांतल्यानूय ताचे जे निवाडे दिले वतात, त्या निवाड्यांक हायकोर्ट, सुप्रीम कोर्ट ह्या लेवलाचेर सुद्धा ताची दाद मागतात. एग्रीव्ड पार्टी जी आसा ती ह्या स्तराचेर वता. आणि असो हो वेगवेगळे इंटरप्रिटेशन्स वेगवेगळे कालाच्या ओघान येवपी वेगवेगळे जे विचार प्रणाली आसा ताजो एक संमिश्र अशा प्रकारचो परिणाम साधून हे राईट टू इन्फॉर्मेशन ऍक्ट आज बऱ्या प्रकारे प्रगल्भ जाल्लो आसा. आमच्या देशान 18व्या वर्साच्या पिरायेचेर आम्ही मतदानाचो हक्क आमकां मेळटा, म्हणजे सुजाण नागरीक जाता. तसो त्या अर्थान एक म्हणजे सुजाण अशा प्रकारचो कायदो तातूंत फाटल्या 18 वर्सांनी भरपूर विचार प्रवाह आयले, भरपूर प्रकारचे तातूंत विचार मंथन जाले आणि हो कायदो एका बऱ्या स्तराचेर पावपाक लागला. सामान्य जनतेच्या मध्ये सुद्धा या कायद्याबद्दल भरपूर जागरूकता आसा. मागीर तो एखादो आपल्या प्रश्नपत्रिकेची कॉपी मागपी एखादो विद्यार्थी आसतलो किंवा आपल्याक मेळपी सबसिडी बद्दल माहिती इनकम्प्लीट आसा किंवा आपल्याक खबर ना म्हणून माहिती मागपी एखादो शेतकरी आसतलो किंवा आपल्या कोर्टाच्या प्रोसिजरा खातीर अर्जंटली एखादो डॉक्युमेंट जाय म्हणून मागपी एखादो फिर्यादी आसतलो किंवा आपण एक जागृत नागरिक आणि समाजीक जे कितें विशय असता त्या विशयाक वाचा फोडपा खातीर म्हणून जागरूकपणे काम करपी एखादो चळवळीतलो कार्यकर्तो आसतलो. ह्या सगळ्यांक माहिती दिवपाचे आणि समाज आणि सरकार ह्या दोन प्रणाली मधलो दुवळ जावपाचें काम हो रायट टू इन्फॉर्मेशन ऍक्ट करता. आणि तुम्ही आमी सगळे हांगाचे जमल्यात ते ह्या प्रणालीचो एक भाग आसा. ताका लागून म्हाका खूब खोस भोगता की आज तुम्ही मोठ्या संख्येन हांगा जमल्यात. आणि म्हाका ही खोस भोगता की आज आमच्या मदीं लर्नेड ऍडव्होकेट जनरल देविदास पांगम जे आसा, ज्यांच्याकडे प्रदीर्घ असो लिगल क्षेत्रातलो अनुभव आसा. ताणे आपल्या कारकिर्दीन भरपूर अश्यो वेगवेगळ्या प्रकारच्यो म्हणजे सर्व्हिस मॅटर्स आसतल्यो किंवा सिव्हिल मॅटर्स आसतल्यो, क्रिमिनल मॅटर्स आसतल्यो, कॉन्स्टिट्युशनल मॅटर्स आसतल्यो, वेगवेगळ्या प्रकारचे विशय हाताळ्या कारणान आणि प्रदीर्घ अनुभव असल्या कारणान ते आमकां मार्गदर्शन करतले. आता तशें पळोवंक गेलें जाल्यार आमचो जो रायट टू इन्फॉर्मेशन ऍक्ट आणि ताचे रुल्स आसा तातूंत पळोवपाक गेलो जाल्यार फर्स्ट एपेलेट ऑथॉरिटी हाच्या बद्दल तशें खूब त्रोटकपणे बरयल्लें आसा. तांचे पावर्स, तांचो स्कोप ऑफ वर्क, डोमेन कितें आसा हाच्या बद्दल आनीकूय क्लॅरिटी येवप गरजेचें आसा. आणि हे येवपा खातीर फक्त सरकारान काम करूंक जाय अशें न्हय, फक्त कमिशनान कितें डायरेक्शन्स दिवपाक जाय अशें न्हय, तर तुमचे कडल्यान त्या प्रकारचो प्रोएक्टिव्हनेस येवपाक जाय. कारण तुम्ही जे फर्स्ट एपेलेट ऑथॉरिटी म्हणून हांगा बसल्यात, फर्स्ट एपेलेट ऑथॉरिटी हो तुमच्या कार्यकक्षेचो एक भाग जालो. पूण त्याच बरोबर जे पब्लीक इन्फॉर्मेशन ऑफिसर्स जे तुमच्या हाता सकयल काम करतात, जे तुमच्या इन्स्ट्रक्शनाचेर काम करतात, तांकांय गायड करपाची गरज आसा. कारण पब्लीक इन्फॉर्मेशन ऑफिसर असो किंवा फर्स्ट एपेलेट ऑथॉरिटी असो, तो इनहेरंटली चार गोष्टी शिकून आयिल्लो नसता. ओव्हर द पिरियड ऑफ टाइम इव्हॉल्व जाता. माहिती कोणाक पयलीं डायरेक्ट खबर नासता की हांवें कितें करपाक जाय किंवा कितें, हाचेर अभ्यास करपाची गरज आसा. फक्त टिपिकल एखादो स्टँड घेतलो की ना ही माहिती दिवपाक मेळना अशें पीआयओन म्हणलें की ते फर्स्ट एपेलेट ऑथॉरिटीन रिएटरेट करपाक जाय अशें खंयच हार्ड अँड फास्ट ना. त्याचबरोबर जेन्ना फर्स्ट एपेलेट ऑथॉरिटी म्हणजे आम्ही जेन्ना आता कमिशनचो कारभार पळयतात तेन्ना लक्षात येता की फर्स्ट एपेलेट ऑथॉरिटी गिव्स डायरेक्शन्स टू कंप्लाय विथ सर्टन रिक्वेस्ट दॅट वर मेड इन द ओरिजिनल एप्लिकेशन बाय द एपेलंट. हावेवर ती ऑर्डर दिल्या उपरांत फर्स्ट एपेलेट ऑथॉरिटीन अपहोल्ड केले की बाबा ही माहिती तुवें दिवपाक जाय आशिल्ली ती दी अशें जेन्ना सांगता तेन्ना तो पब्लीक इन्फॉर्मेशन ऑफिसर जेन्ना ताका ही डायरेक्शन्स वता तो कंप्लाय करता की ना हाजो एक चेक करपाचो मेकॅनिझम हो फर्स्ट एपेलेट ऑथॉरिटीन जर डेव्हलप केलो आणि ताचो कंप्लायन्साचो जर एडहेरन्स केलो जाल्यार आमच्या लक्षात येतलें की जे ग्रीवन्स आसा लोकांचो की आपल्याक माहिती मेळना, इनकम्प्लीट मेळटा, हो ग्रीवन्स कमी जावपाक खूप मदत जातली. नंबर ऑफ अपील्स विल सबस्टॅन्शियली रिड्यूस. कारण कितें जाता पीआयओ not necessarily may understand the significance of that particular this application. He may for the sake of as a part of his routine work, because PIO is also interested with a lot of administrative work, so he might cite various reasons की बाबा आपल्याकडे इन्फॉर्मेशन ना किंवा आपल्याकडे ऍप्लिकेशन यायला ते वेग असा अशा प्रकारचे कितें तरी कारण सांगून जर समजा इन्फॉर्मेशन दिवपाक रिजेक्ट करता जाल्यार खंय ना खंय तरी ताजो एप्लिकंटाचो जो रायटफुल क्लेम आसा त्या इन्फॉर्मेशनाचेर तो अपहोल्ड करपाची जबाबदारी ही फर्स्ट एपेलेट ऑथॉरिटीचेर आसा. म्हणून फर्स्ट एपेलेट ऑथॉरिटी ह्या नात्यान तुम्ही जे हांगा सगळे बसल्यात तुमचे कडल्यान म्हज्यो दोन माफक अपेक्षा आसा. एक म्हणजे तुम्ही हो रुटीन प्रोसिजर जो आसा तो रुटीन प्रोसिजर आणि मातसो प्रोएक्टिव्हली जर तुम्ही तातूंत लक्ष घाले आणि तुम्ही जे पीआयओ जे आसा तांच्या बरोबर कॉन्स्टंटली इंटरॅक्ट करून तांकां जर तुमचे जे अंडरस्टँडिंग आसा ह्या सगळ्या विशयातले ते एट पार जर हाडपाचो प्रयत्न केलो जाल्यार पीआयओ स्तराचेर जे इन्फॉर्मेशन रिजेक्ट जावप किंवा इन्फॉर्मेशन इनकम्प्लीट मेळप हो जो विषय आसता तो सबस्टॅन्शियली रिड्यूस जातलो. अनावश्यक माहिती दिना ताच्या बद्दल आमचे काय म्हणणें ना, पूण जी आवश्यक माहिती असता एखादे इन्फॉर्मेशन असता जे दिवप गरजेचे आसा पूण ते दिना आणि ताका लागून ग्रीवन्स क्रिएट जाता तो सुरवातीकूच जर तुम्ही डिफ्यूज करपाचो प्रयत्न केलो किंवा इन्फॉर्मेशन प्रॉपरली दिता किंवा दिना जाल्यार सुद्धा ताचे जस्टिफिकेशन व्यवस्थित दिता असे जर प्रकार झाले जाल्यार ह्या कायद्याचे इम्प्लिमेंटेशन करपाचो जो स्पिरीट आशिल्लो, कारण कायदो हो सदांच इट हॅज टू बी अपहेल्ड इन लेटर एज वेल एज स्पिरीट, सो ताका लागून ह्या कायद्याचे स्पिरीट आमी लक्षात घेवपा खातीर आयज लर्नेड एजी आमकां ज्या विशयाचेर मार्गदर्शन करतले तो टॉपिकूच असो आसा की द रोल ऑफ फर्स्ट एपेलेट ऑथॉरिटी इन अपहोल्डिंग द स्पिरीट ऑफ दिस RTI ऍक्ट. सो ह्या निमतान तुम्ही सगळे जमल्यात आणि हांगा येत्या व्हडल्या संख्येन येवन ह्या कार्यक्रमाक तुम्ही एक बरी ताचो दर्जो वाडयलो आणि तातूंतल्यान बरें इंटरॅक्शन जावन कमिशन आसत किंवा तुम्ही आसात, ह्या सगळ्यांच्या कॉन्ट्रिब्युशनांतल्यान आरटीआय ऍक्ट आणि आमच्या भारतीय संविधान द कॉन्स्टिट्यूशन ऑफ इंडिया हाणे जे ले डावन केल्ले एक स्पिरिट आसा, जे पॉवर टू द पीपल आसा, ह्या विशयान आमी एक बरो आमचो कॉन्ट्रिब्युशन करूया असो आशा व्यक्त करता आणि तुमकां सगळ्यांक परत एकदा येवकार दिता. देव बरें करूं.
थँक यू व्हेरी मच स्टेट इन्फॉर्मेशन कमिशनर सर. आणि आता आम्ही मुखार सरूया. प्रेमाचे प्रतीक म्हणून फ्रूट बास्केट आमच्या सगळ्या मानेस्तांक आम्ही भेटोवंक सोदता. विनंती आसा सगळ्यात पहिली बाय उत्कर्ष हाका की तांच्यांनी आमचे जे ॲडव्होकेट जनरल आसता देविदास पांगम सराक की तांच्यांनी हे फ्रूट बास्केट प्रेझेंट करचे. तर अशी विनंती आसा आमच्या मदीं श्री अरविंद कुमार एच नायर आसा, गोवा स्टेट चीफ इन्फॉर्मेशन कमिशनर, तांकां फ्रूट बास्केट प्रेझेंट करचे. बाय दिपाली विनंती करता आमच्या मदीं स्टेट इन्फॉर्मेशन कमिशनर श्री आत्माराम बर्वे सर आसा, तांकां भेटवस्तू दिवची. तशेंच बाय मनाली विनंती आसा आमच्या खात्याचे डिपार्टमेंट ऑफ इन्फॉर्मेशन पब्लिसिटीचे डिरेक्टर दीपक बांदेकर सरांक. तशेंच सुधीर केरकर सेक्रेटरी गोवा स्टेट इन्फॉर्मेशन कमिशनर हांकां बाय उत्कर्ष सगळ्यांक देव बरें करूं. तुमकां सगळ्यांक खबर आसता की लायट प्रकाश ही आमकां दिका दाखयता, प्रकाश ही आमकां वाट दाखयता, प्रकाश आमची जीण फुलयता. आनी सामकार सुंदरशी सजिल्ली दिवली आसा आनी ह्यो दिवलेंतल्यो वाती आमकां रावता पळजळीत करपाक. सगळ्या मानेस्तांक विनंती आसा की ह्या दिवलेंतल्यो वाती तांच्यांनी कृपया पळजळीत करच्यो. सगळ्यांक विनंती आसा की आमच्या मध्ये आसा श्री देविदास पांगम ॲडव्होकेट जनरल, अरविंद कुमार एच नायर, थँक यू व्हेरी मच. खूप खूप आभार. देव बरें करूं. We have with us Sri Arvind Kumar H. Nair, Goa State Chief Information Commissioner. I request sir to kindly guide us. Sir, please.
Good morning to all. Learned Advocate General Sri Devidas Pangamji, State Information Commissioner Sri Atmaram Barve, Director Information Publicity Bandekarji, then Secretary Goa State Information Commissioner Sudhir Karkar, and all first appellant authorities here, then ladies and gentlemen and our all media friends. Being the new Chief Information Commissioner of Goa, this is my first public function and I am very happy to deliver a speech on the occasion of Right to Information Day, which is celebrated every October 12th. But today we are observing this because tomorrow it is a holiday, that's why. So basically I want to give a speech on the Right to Information Day, and I think being the first appellate authority, all officers are well aware of their rights, duties, obligations and responsibilities. But even then, on this occasion, I have to give a speech on this Right to Information Day. Right to information as provided in RTI Act 2005 draws its genesis from Universal Declaration of Human Rights 1948, International Covenant on Civil and Political Rights 1966, and Part 3 of the Constitution of India, which enumerates fundamental rights. Right to Know Day is celebrated on 28th September at the international level after UN General Assembly had proclaimed September 28 as International Day for Universal Access to Information. On the other hand, India has been celebrating RTI Day on October 12th as the RTI bill, which was passed by the Parliament on 15th June 2005, came into force with effect from October 12, 2005. The Right to Information Act 2005 provides a practical regime for people to exercise their fundamental right to information by accessing information from the public authorities. The preamble of the RTI Act 2005 states, democracy requires an informed citizenry and transparency of information, which are vital to its functioning, and also to contain corruption and to hold government and their instrumentalities accountable to the governed. The Supreme Court of India on many occasions held that the right to information is a fundamental right flowing from Article 19, bracket 1, bracket A, that is freedom of speech and expression, and Article 21, that is right to life and liberty of the Constitution. With the enactment of RTI 2005, every citizens of India have been given the right to seek and receive information. The Act acknowledges that sharing of information by public authority lead to good governance by promoting transparency, accountability, and containing corruption. Under RTI Act, information commissions are the final appellate authority and are mandated to safeguard and facilitate people's fundamental right to information. The object of the RTI Act is to harmonize the conflicting public interest, that is, ensuring transparency to bring in accountability and containing corruption on the one hand, and at the same time to ensure that the revelation of information in actual practice does not harm or adversely affect other public interests, which include efficient functioning of the government and preservation of confidentiality of sensitive information. Challenges during implementation of RTI includes misuse or abuse of RTI mechanism, shortage of staff, poor information delivery at POO level, backlog of as well as delays of appeals. The core of the right created under Section 3 of the Right to Information Act in reality rests on the duty to perform statutory obligations. Public accountability is a crucial feature that governs the relationship between duty bearers and right holders. Accountability has three essential constituent dimensions. 1. Responsibility. Second, answerability. And 3, enforceability. Responsibility requires the identification of duties and performance obligations of individuals in authority and with authorities. Answerability requires reasoned decision making so that those affected by their decisions, including public, are aware of the same, and enforceability requires appropriate corrective and remedial action against lack of responsibility and accountability to be taken. The purpose and object of the statute will be accomplished only if the principle of accountability governs the relationship between the right holders and duty bearers. In the absence of effective grievance redressal laws, people often invoke RTI in an attempt to force the government to redress their complaints by seeking information about the action taken on their complaints. As far as the RTI Act is concerned, Public Information Officer or PIO has a very paramount role. The flow of information as well as the root cause of an appeal originate from the PIO, who is responsible for receiving and processing applications for functions being performed by the public authority. The Act has not specified level of PIOs, but ideally PIO should be a senior person in the office so that they have the authority to make decision on whether to furnish information or not. But in practice, majority of the PIOs in public authorities is from lower level, and most of them are not adequately aware of their role and functions as well as their relevance in the RTI Act 2005. Section 4 of the RTI Act 2005 states that each public authority has an obligation to provide as much information suo motu to the public at regular intervals through various means of communications so that the public have minimum resort to use this act to obtain information. The RTI Act 2005 underlines the importance of records management by every public authority. Section 4(1)(a) of the Act necessitates a crucial or critical review of the existing record management practices, a record retention schedule for different categories of records, and system of indexing as well as numbering of records. Various studies pointed out that two important factors contribute to the problem of large backlog in the commissions. First, lack of penalty imposition by the commissions, which fosters a culture of immunity and encourages POs to take liberties with RTI Act. Second, the poor implementation of Section 4 of the RTI Act. Section 4 deals with the obligation of the public authorities, under which public authorities are obliged to proactively disclose information. Penalty clause is one of the key provisions in terms of giving the Act its teeth and acting as a deterrent for PIOs against violating the law. But PIOs shall be given an opportunity of being heard before any penalty is imposed on him. Section 20 within bracket 2 empowers the Information Commission to recommend disciplinary action against a PIO for persistent violation of one or more provisions of the Act. Awarding compensation can also be an effective tool to ensure compliance with Section 4 of the Act. But the Commission, especially Goa State Information Commission, does not want to promote the provision of compensation because it will lead to the flow of appeal to the Commission. Section 8 of the RTI Act lists the exemptions to disclosure of information. It is critical that exemption clauses be properly interpreted to ensure the information that deserves protection is safeguarded, but exemptions are not loosely applied in a manner that restricts people's right to information guaranteed by the RTI Act. The stakeholders of this Act must ensure that exemptions are properly and specifically applied. Public interest must be the primary test of all privacy claims, and claims for privacy should be carefully weighed against public interest. Studies on the implementation of Section 4 of the RTI Act claims that the Act empowers the Commission to impose penalties only on PIOs, while the responsibility of ensuring compliance with Section 4 of the Act is actually rests with the public authority rather than with the specific PIO. These studies suggest that perhaps the most effective way of dealing with this problem is to make HODs personally responsible for ensuring compliance with provision of Section 4. This would be in keeping with the general administrative practice, considering that the ultimate responsibility for the functioning of a public authority lies with the head of the department. Often, RTI applications are filed because there are unattended grievances that the public has with the public authority. There are three dimensions of information, namely complete, accurate, and timely. In spite of best efforts of PIOs, there is possibility for some bona fide errors in terms of completeness, accuracy, and timely response to the applicant. To protect a PIO for the action taken in good faith, Section 21 of the RTI Act provides that no legal proceeding shall lie against any person for anything that is done or intended to be done in good faith. Following few points are put forward by this Commission to all public authorities in the state for the effective implementation of the RTI and to make the benefits of the provisions of the Act available to the common man. First, proactively disclose information meant for the general public. Second, information that is proactively disclosed must be properly categorized and organized in such a manner that it facilitates easy retrieval. Third, conduct periodic audits to identify the type of information that is being repeatedly asked for in RTI applications received by them. Fourth, set up RTI cells in public authorities for effective implementation of the RTI Act. And the last point, evolve a mechanism to monitor the compliance of first appellate authorities order by the PIOs. These are the 5 points the Commission has put forward for your consideration and necessary action. And one more point I would like to share with the appellant authorities, that being the first appellant authorities, you people might have come across various issues or difficulties or problems. And such kind of information you can very well convey to the Commission, and we will analyze, and after analyze we will come out with some kind of solution how this kind of issues we can resolve. Because Commission, then PIOs and First Appellant Authority, these are the key players under the Act. So we should not give any kind of opportunity to create any kind of hurdles to the functioning and the implementation of the RTI in its letter and spirit. So you can have the liberty to come forward and convey your difficulties to the Commission, and we want to study the issues, and we will find out a solution to that kind of issues. And this is my speech, and thank you for their work. Thank you.
माहिती हक्क कायद्याखाला आम्ही कितले कंप्लीट एक्युरेट आणि टायमली असपाक जाय याची सविस्तर माहिती सरान आमकां दिल्ली आसा. तशेंच माहिती अधिकार हाच्या विशीं तांच्यांनी सविस्तर आमकां सांगला. तशेंच रोल ऑफ PIOs आणि PIOs हाच्या संदर्भातूय तांच्यांनी सविस्तर अशी माहिती आपल्या भाशणांतल्यान केल्ली आसा. माहिती हक्क कायद्यान सगळ्यांक एक नवी दिका दिल्या, एक नवो जबाबदारी दिल्ली आसा. आणि माहिती हक्क कायदो कितें हे प्रत्येक खबर आसा, पूण आमच्या मदीं आसा माहिती हक्क कायद्याच्या अंमलबजावणीत पहिल्या एपेलेट अधिकारीची भूमिका, अर्थातच रोल ऑफ फर्स्ट एपेलेट ऑथॉरिटी इन अपहोल्डिंग द स्पिरिट ऑफ RTI एक्ट हाचे विशीं उलोवपाक हांव विनंती करता एडवोकेट जनरल श्री देविदास पालगम सराक. सर प्लीज.
Namaskar to all of you. Firstly, I am grateful to the Information Commission and the department for having me here and inviting me for this special occasion. And I thank all of you also for gathering here and gracing this occasion. Amongst us today we have the Commissioner, Mr. Nair, Mr. Barve, Chief Commissioner, Mr. Nair, Mr. Barve, the Commissioner, the Secretary, Mr. Kerkar, and Bandekar, the Director. Without going much into the pleasantries, I can straight away start with whatever my duty that is cast upon me today. In fact, it is a difficult task because as Mr. Barve has already stated that as far as first appellate authority is concerned, there are one or two sections in the Act and the rules are also completely silent about it. So I think they have rightly chosen the subject as to the role of the first appellate authority. Because as far as you are concerned, being a first appellate authority, you must be also looking out for some material in the form of act or rules to find out exactly what you are supposed to do. And even as a lawyer, when I started studying for this matter since morning, I realized that one or two sections are there as far as first appellate authority is concerned. So therefore, the subject and the topic that is chosen today is really worthwhile and is very, very important as far as operation of this act is concerned. So, how to understand this issue as far as role of first appellate authority is concerned? Now, if somebody wants to learn something or to understand a particular problem, they say that you have to first go and understand the history about that particular topic. If you know the history and then you know the purpose and objective of that particular act or the provision, it becomes very easy for anybody to understand it, implement it and operate it. So let us try to understand what is a history about this particular act. In fact, this act is implicit in the Constitution of India. As you know, Article 19 of the Constitution gives a class of fundamental rights to every citizen. Now, mind you, that this right is conferred upon only citizens of India. It is not conferred upon any other person. like in the constitution, at many places you will find the phrase citizen is used, and at some places you will find the word person being used. Now when the phrase citizen is used, that right or that duty or whatever provision is made, it is only for the citizen. But when the phrase person is used, that right or power is conferred on every person, whether he is a citizen of India or not. So Article 19 is exclusively for citizen, among several other rights, including right to move around the country, a right to profess your profession or trade, so on and so forth. One of the first right, which is Article 19(1)(a), is a right to or a freedom of expression, basically. Now, how you say, or somebody may argue that this freedom of expression, how it encompasses the provision of the Information Act. Now, when we talk about expression, how can you express yourself? Now, for the purpose of expressing something, you should have some knowledge about the thing. That means you should have information. Unless you have an information, it is not possible for anybody to express yourself. I can express about today's function because I have information about today's function. I can express today on this subject because I have information about this section. So, the basis of expression is actually the information. Whatever information which we have or which we derive from the surroundings, that is expressed only if you have an information. So that is how the right to information is implicit in Article 1(a) of the Constitution of India. And somebody may argue, and it is really worth to argue to say that yes, this is there in the Constitution, but does it mean that this right is not a natural right? Is it necessary that it ought to have been included in the Constitution for the purpose of a citizen of India to have this right inherently? Imagine a situation if this Article 19(1)(a) was not there in the Constitution. Would it mean to say that the citizens do not have right to information? No. This right is still there. Because this appears to be a natural right. It is not a right. It is only a right that is recognized by the Constitution. This right is inherently there with us. It can be read into Article 21 of the Constitution, which speaks about a right or freedom or liberty, right to live. It is a facet of right to live or liberty. So this is a right, apart from being a constitutional right, it is a natural right which is inherent in any free society, in any civilized society. This right has to be there, or it is there. But what does this right to Information Act does? It only prescribes for a procedure, forum, and consequences of not providing the information which is desirable. So that is what that act does. Otherwise, this is a right which is there in the citizen inherently under the Constitution as also as a natural right. Now, going back a little bit, this issue really came up before the Supreme Court in one of the judgments, which is called as Judges 1 case. This was a case called as SP Gupta versus Union of India. Somewhere in 1978 or 80, between that period, a lot of judges of the High Courts were transferred. Now, that came to be challenged by one of the lawyers of the Supreme Court before the Supreme Court, and which is a legendary judgment of 7 judges. And in that judgment, the Supreme Court recognized this right. It has actually narrated certain observations or judgments from England, and thereafter it referred to earlier judgment of the Supreme Court itself. And what it says is, amongst several other things, is that in democracy, what is desirable and what is contemplated is an open government. Now, what is open government? Open government is that there should be a transparency. And why this transparency is required? This transparency is required not only for the benefit of the people, but it is required for the benefit of the government as well. Now, somebody may ask why government requires a transparency. Government requires transparency because the policies of the government, the decisions of the government, if they are not transparent, if the people are not aware of these policies or the reason behind taking particular decision, then what happens is the people are not aware or they don't become aware of the purpose and intention of having particular policy or having a particular approach. Sometimes what happens is, it is possible that the general public may have one perception about one policy decision of the government. They may have a feeling that particular decision of the government is tainted with some oblique motive. But if there is a transparency, if the information which is there in the files of the government is made public, then there is a clarity, and this misinformation or misunderstanding amongst the government or amongst the people is to a certain extent avoided. So that is one of the purposes of having this Right to Information Act, so that the misunderstanding among the people is avoided. The second advantage which the government has when there is a Right to Information Act is that there is always a feeling in the mind that whatever decision I am taking today will be in public domain subsequently. So the decisions which I take, I am aware that they may be scrutinized in public, and that puts me on guard so that I do not make a mistake or I do not act in such a manner that I will be subjected to a public scrutiny in future time. So that makes a government officer more responsible. But apart from this advantage which I am talking about in favor of the government, there is one disadvantage which I have realized, is that many a times, and it is expected in democracy and any setup of democracy, that the officer of the government or whoever takes a decision or recommends something has to have a free hand in putting his opinion or advice freely on the paper. But I have seen on many occasions that this opinion or the advice on the papers or notings is not put freely because of the fear that if this goes for scrutiny in public domain, then there may be a problem. So there is this disadvantage or demerits in this Right to Information Act, or the information that is being dispensed under the Right to Information Act. So this is one minor disadvantage, but generally there is an advantage for the government and the government officers, that there is a transparency, people can understand, people know what is the reason why this decision is taken, and officers and the government is also aware that this will be subject to the public scrutiny. Therefore, the decisions are taken in such a manner that there is no doubt in the minds of the people. So this is the advantage and purpose for which this law is required. That is what the Supreme Court says in the case of SP Gupta. Now what happens thereafter is, after 81, what happens is, there was a meeting that was held of the chief ministers somewhere in 1997 in Delhi on the topic called as effective and responsive government. Now in this meeting, there was a wholesale debate as to how government should be made effective and responsive. One of the thoughts that came in this meeting was to provide for information to the public, basic knowledge of the government functioning to the public. And that is how all this exercise started. There was a committee that was constituted under the chairmanship of Mr. S.D. Shauri. This committee recommended that there has to be an act to regulate this information. The information should be given to the people, a law should be made. And this happens in the year 1997. And for almost 5 years, there was nothing much that was done. But in 2002, when Mr. Vajpayee came to power, he is the one who pushed for this act. And what happened was, in 2002, an act called as Freedom of Information Act 2002 came to be passed. Now people think that Right to Information Act is the first act that was passed as far as Information Act is concerned. It is not so. There was an act called as Freedom of Information Act which was passed in the year 2002. But there was certain problem of implementation of this act. So therefore, it was not implemented because of all those problems. Thereafter, there were proper studies that were conducted, and in the year 2005, literally the very same act has been enacted, except for one change that has happened, is that the state commission has been constituted under the Right to Information Act. Otherwise, rest of the provisions of freedom of Information Act are identical, which are contained in the Right to Information Act. So they are almost the same. So this is little bit of the history of the Right to Information Act. Now coming back to the topic which I am supposed to talk today. It's a difficult topic, as I told you, because the rules are silent on this, the Act is silent on this. The Act only says that if there is a refusal of information by the PIO, an appeal would lay to the appellate authority, which will be called as appellate authority, which will be authorized by the government as the first appellate authority. It further says that the appeal has to be filed within 30 days, and the last thing it says is that the appeal has to be disposed of within 45 days. These are the only three parts which are there in this. So therefore now, what the appellate authority is supposed to do? Appellate authority does not know what are its power. Nowhere it is written as to what appellate authority can do. What can the appellate authority do? Whether it can say that I am directing the PIO to give the information. It doesn't mention that PIO, the appellate authority can say that I am remanding the matter back to the PIO. It doesn't say that the appellate authority may direct the PIO to remain present for the purpose of hearing of the case. The appellate authority, whether it can direct the PIO to file a reply, whether an affidavit can be filed, absolute silence. Nothing in the Act, no rules are framed as far as first appellate authority is concerned. The rules are there in respect of the Commission, that is the second appellate authority. But as far as first appellate authority is concerned, there is a complete silence. But then what do you do? What in such a situation, what do you do? Does it mean that the appellate authority is powerless? No, it is not so. Now, the first principle in law is that when we talk about an appellate authority or when we talk about the appeal, it inheres in that appellate authority the same powers which are there in the original authority. So, the law is that the appellate authority has the same powers which the original authority has. That means in this case, it is the powers and duties which are conferred upon the PIO. Those are the powers and duties will have to be performed by the first appellate authority. So every power which the original authority, that is the public information authority has, the same powers will be there with the appellate authority. So remember that your powers are at par with the original authority. This is the first thing. The second thing is now, there are, when this type of situations arise, like for example, if the Act is silent, the rules are silent of the powers of the authority which is supposed to perform a duty under the Act or the statute. There is a principle called as incidental powers. Like, what are these incidental powers? An authority which has a power to, let us say it has a power to construct a road. This is the power that is given to the authority. Now, somebody may say that can that authority acquire the land for the purpose of constructing the road? Yes, it has. Because this is an incidental power. Because the main object of that power or that duty is to construct the road. So whatever is required to be done for the purpose of execution of that power, the authority will have all incidental powers. Now in this case, as far as appellate authority is concerned, the power of the appellate authority can be, and this is not sort of a complete answer which I am giving. There are cases and cases in which issues will arise as to, in this particular situation, what powers can be exercised by the appellate authority. But as far as illustrations are concerned, I can give you few illustrations. Supposing that appeal is filed before the appellate authority. Now what does the appellate authority do? The appellate authority is supposed to issue a notice to the PIO. And PIO is supposed to file a reply. So the appellate authority can direct the PIO saying that you file a reply. Now further there is a silence as to what happens if there is a third party information that is supposed to be given. Now is it required that at the appellate stage the third party has to be called? Yes, you are supposed to call. Although it is not provided in the Act or the rules. you are supposed to call the third party in case the issue arises as to whether the information about the third party is supposed to be given. There are other exceptions which are there under section 8. If they are applicable in that case, then you may have to notify a person. Like for example, if there is going to be a breach of copyright, then in such a situation you will have to issue notice to that party which may not be a party before you, whose rights under the Copyright Act may be infringed. You are duty bound to issue a notice, although such a power is not there. You are entitled to, or you are liable to hear the party who are going to be affected. You can call them, you can direct them to file an affidavit, you can direct the appellant to join somebody as a party. These are all incidental powers which are there with the appellate authority, although these are not prescribed in the Act or rules. Now, you may not have some powers which may be there with the commission, or which may be there with otherwise any other authority which decides some rights of parties. But incidental powers like commission has specific power to impose a penalty. Commission has a specific power to impose a cost. Commission has a specific power to enter something in the CRs of the officer. Such a power is not an inherent power nor an incidental power. These are substantive powers which are conferred upon the commission. Those powers are not there with the appellate authority. Now, one thing I can advise you or suggest to you is that, as has been spoken by the earlier speakers, the object of this act is to dispense information. Remember one thing, and this is applicable even to the PIOs, that the object of the act is giving information is a routine thing. Giving information is a rule, and denying information is an exception. Possibly, the test which may have to be applied when you reject an information is, except for section 8 which is prescribed and prohibited information, you have to apply one small test. If you can apply it, I think it will operate smoothly. That in a rarest case, you should reject an information. All other informations should be dispensed. Secondly, you remember one thing. One of the tests which is there in the Act is that any information that can be given to the state legislature, that means the assembly, all that information you are bound to give. You cannot deny it. So this is a simple test. You must have come across those LAQs, and you must have experience now that what type of information you give to the assembly. So all that information which can be given to the assembly is liable to be given. So remember simple things, that you have to give information in everything except for which are prohibited in the Act. One is if there is a breach of copyright, if there is going to be an impact on the sovereignty of India, if there is going to be impact on the security of the nation, if it is concerning with the criminal investigation, if it involves any breach of copyright, so on and so forth. It is specifically provided. Rest all information you can unhesitantly you can give it. This is the crux of this act. This act is the most simplest act which I have come across. It specifically provides that these are the information you shall not give, rest you are bound to give. You don't have to have much arguments on all the other subjects. You have to only ask the person who is opposing this information whether you fall in these exceptions. If he is able to make out that he falls in this exception, then only you should deny. Rest you can simply sit or give information without giving much reasons, saying that it doesn't fall within this exception. You don't have to justify why you are giving this information. And that, in my view, will solve all these problems. Now, what happens is, the commission is flooded with these cases is because of the lack of knowledge about this act, only to an extent to the extent what I have stated, that the first duty is to give the information. In one exceptional cases, maybe 1 in 500 cases or 1000 cases, you can reject because of the involvement of some personal rights of any person. But even personal rights can be also given if it is in public interest. That is also there. So therefore, keep it in mind that your role is to give the information. You hardly have a choice to deny information. Denial can be only on those 4 or 5 grounds which are there. I think this act will move smoothly, it will operate smoothly, pendency of the cases will be reduced. The proceedings which the officers suffer before the commission, like for example, procedures or proceedings for imposition of fine, penalty, then about CRs, etc., will be reduced to minimal if you keep this principle in mind that you have to give all the information except which is prohibited on those 5 counts. So that is the way you can operate. Now what you have to remember is that the object of this act is to give everything to the public, everything to the citizen. If that is being given and that is being dispensed and that is made public, then there is no problem about the operation of this act. Now other thing what you can remember is this, which is for everybody. Like as it was pointed out by the Chief Commissioner, that you should audit and find out which are the informations which are sought again and again. Now remember, one of the requirement of the act is that you have to put most of the information about your department in the public domain on your website, or it should be made available on internet. Now what does it do? In fact, it is for the benefit of the officers. Although it is intended to be for the benefit of the public, but it will be more benefited to the officers. If this information is available on the net, on your website, if somebody applies for this information, if 10 people apply for this information, your work will be reduced. They will not apply if it is there in the public domain. And even if they apply, in one line you can send them an email that this information is available on my website. So you can reduce this work so much that it can be minimal to maybe 1% or 2% of your work. Most of the documents and information, if you make it available on your website, then that will reduce the burden on the system, the burden on the officers, and more often than not the liability on the officers. Because what happens is you are individually held liable. Normally government servants are not individually liable for any fault. But under this act, the government officers are individually made liable for any fault or any delay. That is what you should remember and try to do it, and that is one of the duties. Initially I remember when this act came into force, there was a lot of efforts made by the government for uploading all this information on the website of the particular department. You have to now try and actually do it again. If you do that, most of the issues will be sorted out. Now I am told that even the commission has gone online. They are also holding VCs and online hearings. That is also something which we have to appreciate. They were expressing one issue as far as securing of the presence of the PIO in their second appeals. The replies get delayed. That is how those proceedings get delayed. So that is one thing you should remember. Whenever a notice is received from the commission, promptly reply to it. And the best thing is to actually your reply which you have given under the RTI does contain the reasons, whatever reasons are given by you for rejection of the reply or the application that it has. You can simply send an email to them as to what are the facts of the matter, or you can send a file straight away. On the first date of hearing, if you present the file to the commission, that will reduce your burden. In fact, in the rarest of the cases, you may file a reply. Best thing is to produce the file before the commission immediately, and if you produce that, I think it is then it is their job to look into it, and then they don't have to be worried about. Neither you have to be worried about it, because the law requires that whenever they call you, you are supposed to remain present there. But if you present the file, their work becomes easy, and your time is also saved. So that is what one thing you can do as far as smooth functioning of your functions are concerned. So this is what I felt about your duties. There is nothing much I can say about what you should do, because you have a lot of experience in this field now. The best thing is to give the information as early as possible. Do it within 30 days. Direct. Now one of the things which we were discussing was the act is silent as to how to execute the orders of the appellate authority. If the appellate authority passes an order saying that the information should be given to the appellant within, let us say, 30 days time, how to execute this order? That is one of the issues. In fact, there is a lacuna there. The execution of the orders of the appellate authority, there is a complete silence. Possibly on all these scores, rules will have to be made. This procedure for execution, procedure before the appellate authority, powers of the appellate authority, all will have to be prescribed by virtue of rules. If the rules are made, it becomes easier for all of you to function and operate this act. So therefore, let's hope. We were discussing about the framing of the rules. Possibly they will also take up this issue with the government for framing the rules. And the director is here. I think he will do the needful at the earliest. So your problems are minimized at the earliest. So having said so, thank you so much for inviting me here. And I hope that we will make this Right to Information Act success, because it is in the interest of citizens that this act has been made. We are all working for the citizens, and if you operate this act in that spirit, I think one of the major goals of our constitution and the constitution makers would be achieved. We will reach the highest level of development in this country. We can develop only the common man, the last man in the society develops, and one of the means of development is giving information to the people so that they are aware of their rights and they can take action. They can go to the different forum for their grievances, and that is what all we should do and work hard for. Thank you so much. Jai Hind, Jai Gomata.
थँक यू व्हेरी मच ॲडव्होकेट जनरल सर. सुंदरशी माहिती तुमकां मेळिल्लीच आसा. अशा वेळ जाता की केन्ना केन्ना थोडेशे प्रश्न आयकुप्याच्या मनात निर्माण जातात, आणि हे प्रश्न तेन्नाच समजा सुटावे जाले जाल्यार ते योग्य जातले. सो हांव विनंती आसा जे सामके बशिल्ले सगळे आमचे अधिकारी आसा, तुमच्या मनात समजा कितेंय प्रश्न आसत, आमचे CIC आसा, SIC आसा, तुमच्या मनात समजा कितेंय प्रश्न आसत जाल्यार सामकार येवन ते तुम्ही विचारूं येता. प्लॅटफॉर्म इज ओपन फॉर यू. थंयच्यान या सिद्धेश मायक पळय आहा, मायक आसा कोडलेस. ओके. आवाज व्यवस्थित पावता जाल्यार तुम्ही जाग्यार बसून विचारूं येता, पूण आवाज मातसो कळकूच समजा कितें प्रश्न जाल्यार डेफिनेटली तुम्ही विचारूं येता. Yes.
I want to know regarding section 6.3 transfer of application. See, if application is made to the public authority, let us say Directorate of Transport, and if I ask information about branches or sub-offices, such application can be transferred under 6.3 when there is a provision under 5.4.
So please repeat your question, please.
See, if I make an application to the Director of Transport, PIO, headquarters, can that application be directed, transferred to the sub-offices, say Margaon, Panjim, or any other offices under section 6.3 when there is a specific provision under section 5.4 that the PIO has to collect the information from the subordinate offices and pass it on?
See, it depends on the existence of the PIO in that office. See, if there is a PIO in the sub-office, you can transfer it. If there is no PIO there, then you have to call for.
But there is a mention that section 6.3 says to the other public authority.
Correct.
But is the appointing authority or designated officer is say Director of Transport, and can that Director of Transport PIO transfer that application to another PIO because he is not a public authority, another public authority?
No. Please understand. See, we are concerned. You forget that who is your head of the department.
Public authority. It is.
Yeah. We are concerned with the PIO.
Yeah.
If there is one PIO who thinks that this information is not within his domain, it is not available with him, and it is available in the domain of some other PIO, he can always transfer it.
Yeah, but what is the provision for 5.4 then section? Why the section Section 548.
See, many times two different provisions are there for the same situation. So you have a choice. See, you have a choice. Ultimately, what is the object of this act? The object of this act is to give the documents, give the information. See, if you feel that some information is available with another PIO, it is within his domain, you can use your discretion to transfer this application to that officer. But if you feel that it is convenient to get this information by myself immediately, I can take it and give it. Because ultimately, the law, when it speaks about transfer, the law doesn't contemplate a situation that citizen should be made to dance from A place to B place. It is your primary duty to give. Like for example, if an FIR is earlier, what used to happen in a criminal case, a FIR was registered at one police station. He would say that I don't have jurisdiction, okay, and he would keep quiet about it. But now, somewhere 10 years back, there was an amendment made to the CRPC whereby a concept of zero FIR was developed. That you can register an FIR anywhere. Supposing an offence has happened in Goa, somebody can register an FIR in Assam. That Assam officer has a duty to transfer that FIR to Goa. So therefore, this is a central act under which you are an PIO. It is your duty to ensure that the citizen gets. You cannot go into these technicalities. If you feel that I can give the information quickly, take it out and give it. If you feel that it is easy to give the information by officer in Madgaon, you transfer it there. So there is nothing like hard and fast rule. You cannot apply these technicalities to delay giving of information, nor you can deny information on the ground of these
But
technicalities.
the Margaon officer is asking me to visit his office and collect the information. The MAPSA officer is asking me to collect.
If you are really interested in the interest of the citizen, possibly you should go to Margaon. There is nothing wrong in doing that.
I'm concerned.
This is the problem is now don't go into the technicalities. You are duty bound to give the information. You can only say that it is not within my domain. You can transfer it to somebody else.
सर थँक्यू व्हेरी मच. सर थँक्यू व्हेरी मच. आणि कोणाक कितें प्रश्न आसा जाल्यार बी स्पेसिफिक आणि कितें कोणाचो प्रश्न आसा जाल्यार डेफिनेटली तुम्ही विचारू येता. Okay, last, yeah.
Sir, this question is related to 8.1J, personal information. So basically they ask information wherein which vigilance inquiry is happening. They also ask information with respect to service data and all, where we have private information. So in that context, basically I was reading the judgment of CPIO Supreme Court versus Subhash Chandra Agarwal. In that they have specified.
What is your query?
Personal information, what involves, sir? If there is a vigilance inquiry.
See, one of the requirement is that you need not give information where you feel that any investigation is going to be impacted. Like personal information, certain personal information like date of birth, date of entry in service, date of promotion. These are information. There is nothing personal about it. Absolutely nothing personal about it. These have to be given. So what is that personal information you are saying that, like for example, if the vigilance inquiry is going on, possibly vigilance can say that if this information is given, it is going to impact my inquiry. So in such a situation, that information can be denied. But once the inquiry is completed, you are bound to give it. So the stage is important, the time at which you are giving this information is important, and what information you are giving is important. Like supposing that in a particular inquiry, let us say if there is a report of, let us say some health report which is there on record, some information about health of the officer. In some investigation it has come on record. You can as well deny it, saying that this is very, very personal information. So it depends on the information which is sought. If somebody asks me, is there any vigilance inquiry going against this man, and on what ground that inquiry is going on, you can always say that yes, inquiry is going on, these are the grounds. But in that inquiry, let us say, there is some information that has come about his personal affairs, which has nothing to do with his service record. You need not give it, saying that this will involve his privacy. So that is that personal information which is spoken of there.
One more last question. Please, anybody? Last question. Yeah.
No, that's what I said. That power is not there in the first appellate authority. This is not an incidental power. This is a special power, so that has to be conferred by the statute.
Thank you very much.
Thank you.
या सो फाल्यां जशें म्हायती हक्क दीस आनी फाल्यां सुटी आशिल्ल्या कारणान आयज हो दीस आमी हांगासर घडोवन हाडला. सुंदरशी चर्चा, सुंदरशी माहिती प्रत्येकाक मेळ्ळी आसतली. गिन्यानान भर पडप हें प्रत्येकाचें कर्तव्य आनी हें गिन्यान जेन्ना आमकां मुखार व्हरता तेन्ना एक बरी जीण आमकां जगपाक मदत जाता. निमणे सुवातेर वोट ऑफ थँक्स जावच्या पयलीं भायर जेवणाची एक 5 मिनटां भितर